Thank you. Please be seated. This is a time set for oral argument in our case, CV130759, Honeywell versus Kilgore. Each side is allocated 20 minutes for oral argument. Appellant may preserve or reserve a portion of that time, although if you wish to do so, you need to keep track of your own time, and there is, of course, a clock. At the podium, out of respect for counsel, I would ask those in attendance to make sure that their cell phones are off or muted so that argument isn't interrupted. We have read the briefs. We've conferenced the matter this morning. We're familiar with the record, and we'd encourage you to keep that in mind as you present argument today. Our proceedings are being recorded and will be posted to YouTube in due course. Accordingly, I would ask that you announce and tell us the party that you represent as you begin your oral argument. With that, let us first hear, from Mr. Hammerman.
Good morning. My name is Stan Hammerman. I represent Honeywell in this particular case, and please the court and please counsel. The court, of course, is familiar with the Uniform Enforcement of Foreign Judgments Act and is familiar with the full faith and credit clause of the Constitution. That particular act and that clause affords that a sister state judgment is valid in the state of Arizona with a number of exceptions. One of the exceptions in that case is a lack of personal jurisdiction, and that was the basis of the lower court's decision in this particular case. I think to determine whether or not error was committed, we need to look at the entire record as to what transpired and how we got here. We got here originally after the foreign judgment documentation had been filed in duly notice, and an objection had been filed by the defendant. And in that particular minute entry thereafter, the trial court judge decided to hold an evidentiary hearing. And the judge states in that particular minute entry, the judge says, after reviewing the parties' papers, the court has determined that an evidentiary hearing is required related to the alleged forgery in the document entitled guarantee and the nail and mail service on defendant Kilgore. A hearing then was subsequently held. So the question is, did the judge make any determination as to whether or not service had been properly served? The judge made no decision. Therefore, we must assume, at least for purposes of this proceeding, that the defendant was in fact served with the original complaint emanating from the state of New York.
Why is that?
Because there has been no determination to the contrary. We must assume, for purposes, if the judge had wanted to decide that there was no service, the judge would have said there was no service. There's more than sufficient evidence to indicate that service was performed on the defendant.
Well, let me ask you, does that, given the judge's ruling, which I'm wondering if you're arguing there's a notice issue with the initial minute entry, but given the judge's ultimate ruling was that the guarantee had to do with something other than the dispute, does it matter whether service was effectuated?
I believe that it matters because the process that the judge utilized to reach the final decision in this case violated what is provided for in the Uniform Enforcement of Foreign Judgments Act, and that is the page-by-page analysis of the contract that had already been determined by the state of New York. That is the problem in the case. It's more of a procedural question rather than a question otherwise. What was the defendant served? For the purposes of this hearing today, the purposes of the record, we must assume that the defendant was served. We must assume that the signature on the contract was not forged because the judge did not rule to the contrary. But I think what's significant, and again, we go to the court's minute entry.
Well, counsel, you know, a lot of times our trial judges don't reach various issues because the ruling that they decided or how they came out with it resolves the whole case without having to determine the forgery or the service of process. And so I guess I'm still not clear that you've answered Judge Thumma's question that, and does it really matter because she resolved it in a way that she didn't need to reach those issues.
And I share your opinion that she did resolve it in a way that she would not need to reach those decisions. However, the method that was utilized in resolving this particular matter was improper. And if you just look at the minute entry that which she ultimately ruled, basically, the trial judge, rather than determining whether or not the underlying judgment is valid, performed a mini trial on merits. If we go to page 2 of the minute entry, at the third paragraph on the bottom, where the trial court says, Defendant Kilgore testified that he consulted for American Alarm Partners, Inc., but never did any work for American Alarm, Inc., Alarm Company. He testified he was not an owner, officer, or director by the company. His consulting work for American Alarm Partners, Inc. consisted only of helping American Alarm Partners recruit and train sales representatives. Defendant Kilgore's testimony was not refuted. Of course it wasn't refuted, because it wasn't necessary to refute it. This was the decision that was made by the New York court that this was a valid contract. The court goes on.
Well, but
Counsel, it seems like you're questioning the court's discretion to hold a hearing, an evidentiary hearing. Isn't it appropriate when you're looking at matters of personal jurisdiction to engage in some kind of hearing?
It is totally valid to go ahead and conduct a hearing. And the court, when the court issued its minute entry, the court said, we are going to determine whether or not this person was served. We're going to determine whether or not this document was forged. Neither of those issues were addressed as we've discussed. So I think it is, of course, valid to discuss that. But the court, to expect the plaintiff then, what we have is we have a defendant who's form shot. The defendant is form shot. The defendant was served with a complaint, and then not until the judgment gets to Arizona does the defendant decide, I'm going to wake up here and I'm going to try to get rid of this judgment. The judgment is still a valid judgment in the state of New York as we sit here today, despite the trial judge's ruling.
Does New York have to give full faith and credit to the Superior Court of Arizona's now current ruling?
The appellee filed something in the state of New York concerning this and then vacated. So right now the original judgment stands. The court went on to say, so the court finds that plaintiff failed to prove that the guarantee allegedly signed by defendant Kilgore on May 8, 2007 is related to American Alarm Company, Inc., the entity that apparently incurred the debt to plaintiff. Well, it talks about choice of law. The problem is, at a foreign judgment hearing, there is no burden of proof other than to say that the judgment valid. It was not the plaintiff's job, or the judgment creditor's job, to prove about the guarantee. This has been done in the state of New York. And that's why I said it is so pivotal that no ruling was made concerning whether or not the defendant was served, that no ruling was made concerning whether or not the defendant signature was forged. Now, the defendant appellate did argue that. It was argued at the hearing. He argued that he wasn't served. They argued that his signature was forged, but the court didn't get there. As Judge Orozco said, they have that. The judge said, I don't like this contract. I don't like the way it reads. Therefore, I'm throwing out the judgment.
Well, it was a little more nuanced than that, wasn't it? I mean, didn't she effectively say this contract doesn't have to do with this specific claim, and that was the basis for personal jurisdiction over the Mr. Kilgore. And because the contract wasn't applicable to these claims, there was no jurisdiction. Isn't that really what she said?
That's what she's saying, but she's doing that by analyzing the contract, by putting on evidence where she said we failed to prove our case. We failed to refute the defendant's testimony. This was not a trial. It was not meant to be a trial on the merits. And that's exactly where the court went askance. The court did not follow what it should have done. And that is this judgment valid? It certainly is arguably valid. The contract certainly looks clean. It's not an illegal contract. I think
It just doesn't apply. That's what she found, right? It didn't invalidate it, didn't find the signature was improper or otherwise, not accurate. It's just this contract doesn't have to do with this case. And because of that, and given that that contract was the only basis for jurisdiction, there's no jurisdiction. Isn't that kind of the chain that she went through?
I did see how she went through that. However, the evidence presented, and to suggest that certain testimony was not refuted, and to suggest that elements were not in fact proven, is then usurping the jurisdiction of the Court of the State of New York, which did in fact find that the contract was valid. And to just sweep it aside and say, I don't like this contract.
I don't think she's.
Assume it was signed.
I don't think she didn't say the contract wasn't valid. She said that it didn't apply to this defendant. She didn't say that it wasn't a valid contract. She said the sole basis of jurisdiction with New York is the guarantee, and the guarantee is not shown to relate to this debt. She's not saying, and so the judgment itself is incorrect or void or whatever word you want to use, but that's the process. She didn't make a determination that this was an invalid contract. What she said was, this guarantee, the four corners of this guarantee do not indicate that that this guarantee went to the debt that you served him, that you're trying to collect from him, and the because it doesn't have an account number, it doesn't say the name of the company. I think that she sets up the facts, but when you look at her order, she's basically saying that there's nothing in this guarantee that relates to this debt that you're trying to collect from this defendant, and the only way New York has personal jurisdiction over this, Mr. Kilgore, is by the guarantee. But the guarantee doesn't relate to the debt that you're trying to collect from him. I don't think she's saying that this is an invalid contract. She's saying it doesn't apply to this Arizona citizen.
And the process that she utilized to reach that determination was not a proper process. The process of expecting the plaintiff to come to Arizona to prove its case, to prove that it did relate to that document, to hold basically what was a trial, when really these issues had been determined by the state of New York, is improper. So I know what she did, but it is indicative of the problems of the case when a trial court tells you, I'm going to hold a hearing. In this hearing, we're going to talk about whether or not the defendant was served. We're going to talk about whether or not the document was forged, and then to go into a page-by-page analysis of the contract. The real question for this court is, can an Arizona trial court attack a New York judgment, which is based on the very contract which calls for a choice of law provision, which was not part of the case? So can that court go through a process, obtaining testimony? Did the plaintiff even have an opportunity to bring in witnesses to testify, yes, this is exactly what was intended? There are a lot of witnesses that could have testified to that, but to suggest that Mr. Kilgore's testimony was unrefuted, of course it was unrefuted.
Tell me about the evidentiary hearing before the judge and whether these issues were raised at that time.
I'm sorry?
Tell me about the evidentiary hearing before the judge and whether the issues that you talk about, which are really, hey, we need an opportunity to refute that, was that point raised before the judge?
I'll tell you it was not raised. It was not raised because it's not this forum's duty to evaluate that evidence. That evidence goes back to the state of New York.
Well, but there was testimony offered, Fair, at that hearing that about what the nature of the guarantee was, what it meant, what it didn't mean. Now, I'm not saying you agree with that testimony. Don't get me wrong, but that was offered there. So the thought that that issue was out there.
Well, the issue surfaced for the first time at the hearing, so it's pretty much impossible.
The issue of personal jurisdiction?
The the issue of the validity of the contract, whether or not the contract pertained to one company or another company, whether or not personal jurisdiction was properly determined by the state of New York. The first time this issue came up was at the hearing.
That wasn't in the motion.
I'm not going to swear that I recall everything. I do know, and the court.
I mean, counsel, it's just, okay, can you back up just a little bit? Are you saying, let me, help me understand what you're saying here. Are you saying that Mr. Kilgore did not have the right to raise the defense of lack of personal jurisdiction in the Arizona Superior Court?
No, I'm not saying that.
Okay, but if he did have that right, then he'd follow it up with a request for a hearing and see that through.
The issues that were raised in both the appellee's opening brief and by the court's minute entry were, hey, I didn't sign it and it was forged. Those were the issues. We then went through a page-by-page analysis of the contract itself. My suggestion to this court is that the trial court went too far. That the trial court did not have the authority to go into the other issues, to analyze the contract, to say that we didn't free it, to say that the evidence concerning the guarantee was not put on. I know I only have 4.5 minutes, so if I can reserve the remainder of my time.
Very well. Thank you, counsel. Mr. Hem, am I pronouncing that name close to right?
Yeah, it's Hemd.
Okay, thank you.
Good morning. May it please the court, I'm here on behalf of the appellee, Mr. Kilgore. Just to
Counsel, could you move that mic back
Yeah.
to center right there?
Just
Thank
to
you.
respond to the some of the arguments raised, I think one important point here is that counsel has mentioned several times that the New York court has decided these issues, and in the sense that they issued a default judgment against the client, they never actually decided it went to the merits of personal jurisdiction. There was no motion practice on it. There was no hearing held. So to the extent that they have personal jurisdiction, you have to just assume that from a default judgment being entered, and I don't think that you can.
Well, there's some decision, at least either, and it's implicit in the judgment that the New York court at least thought they had jurisdiction, correct?
Right, yeah, and I don't think it's not a major point, because I think that under the full faith and credit clause, you can attack for a lack of personal jurisdiction, which I don't think counsel is denying. I think it was clear from the briefs that we were attacking based on personal jurisdiction. I mean, that was one of the main points in our motions that we filed.
But what's your response to the argument that there are many paths to attack personal jurisdiction, and the path that the trial court ultimately found was not one that was noticed in the minute entry setting for or setting the evidentiary hearing?
Well, first of all, I don't think that this notice issue that counsel is raising today was raised in the briefs before you, so I think it was waived. But if that's an area the court wants to go into, certainly a notice that hey, we're looking at these two issues in the evidentiary hearing doesn't mean that the judge can't go back and say, well, you know, this was attached to the pleadings, this was attached to the motions, and you know, I can look at the motions and see, oh, there's an argument based on personal jurisdiction. It includes this. The only way that was attempted to be established by the appellant was through the guarantee, and the guarantee doesn't establish personal jurisdiction. I don't think, even if the hearing could have been on anything, and she can still do that through the motion practice and through what was argued in the motions. And to the extent that her ruling goes through the guarantee, I think that's perfectly acceptable, considering that was the argument that the appellants were relying on, to establish personal jurisdiction is the clause in the guarantee. And to go into that, I don't think that the clause itself establishes personal jurisdiction. If you read the clause, it says that the federal and state courts within the state of New York will have exclusive jurisdiction to adjudicate any dispute arising out of or relating to this guarantee. And saying that the federal and state courts within the state of New York will have exclusive jurisdiction, it doesn't say that it will have personal jurisdiction over Mr. Kilgore. It just says that it will have jurisdiction. And I would argue that that is referring to subject matter jurisdiction, not personal jurisdiction. So even if you look at the underlying guarantee, it doesn't even waive personal jurisdiction. And that has to be, I mean, there's plenty of law that says that has to be clear. It has to be clearly waived. A constitutional right such as personal jurisdiction has to be clearly knowingly, voluntarily, and clearly waived. And I don't think that it's at all clear from the language itself that he was waiving personal jurisdiction. But to get back to more of the focus of what the trial court ruled on, and just to address that really quickly, I think that the trial court, by not ruling on whether there was a forgery or whether there was service, I don't think that means the trial court accepted that there was forgery. There was a forgery and there was service. I think the trial court just didn't get to it. There's all sorts of issues that have been raised in this case and many others that the trial court doesn't always rule on. And just to address the fact that the New York judgment we filed something in New York to enforce this judgment, and the counsel informed me that the result of this appeal would certainly have an effect on whether the trial court's judgment, for example, if this court overturned the trial court's judgment, then obviously that judgment wouldn't be given full faith and credit in New York to vacate their judgment. So he agreed that the result of this appeal would determine the result of the default judgment there. We agreed to that. So to the extent that the judgment still exists there, it does, but it's only pending the resolution of this case. And I would note that the trial court, I think counsel made a lot of the trial court going into the merits and how that seems inappropriate, and I don't think that the trial court went into the merits at all. I think it just realized that the only way that appellants were trying to establish personal jurisdiction was through the guarantee, and so therefore you have to look at the guarantee and see if it in fact established personal jurisdiction. To the extent that an evidentiary hearing goes into people ask witnesses all sorts of questions, I mean I don't think that makes it a ruling on the merits. I think she simply ruled on the issues in front of her. The case I think is pretty simple. I think New York, they're saying the guarantee says that New York has jurisdiction for disputes arising out of the guarantee, and there was no showing that the dispute actually arose out of the guarantee. There's no name on it. There's no account on it.
Who had the burden at the hearing?
In attacking a foreign judgment, generally the person who's attacking the judgment has the burden of proof. So we have to establish that there was no personal jurisdiction. I think that there's ways that burden can be overcome. I think that it's a foreign court judgment. I think it's cited in Collins' opening brief. Foreign court's judgment is given prima facie evidence, and as you know, a prima facie case can be overcome by the opposing party, and I think that was done not only at the hearing but through motion practice, where essentially we argued that the guarantee doesn't apply to our client because many reasons he didn't sign it. It wasn't a guarantee on a loan on a debt that he was he needed to work for the company. And I'd like to just take some time to turn to the attorney's fees issue that we argued on our cross appeal. I think the argument made by appellants was that under Rule 54G, you have to make a claim for attorney's fees in a pleading, and obviously Rule 7A defines pleading, and it says that a pleading is not it doesn't include a motion in the pleading. Now, the court in Balustry expanded that and said that a motion to dismiss is often referred to as a quasi-pleading. You often file it in lieu of an answer, in lieu of a pleading. So they said, well, that can count under Rule 54G as a pleading, and therefore that will bring in Rule 54G and say, yes, you do have to mention it in your motion to dismiss. Now, in this case, what we're trying to do is we're trying to vacate the filing of a foreign judgment in Arizona, and also vacate the underlying judgment. Now, that's not moving to dismiss the case. We're not dismissing the entire case. We're trying to get rid of the default judgment and say based on lack of personal jurisdiction. So,
But you are trying to get rid of the case in Arizona, aren't you?
yes, that's correct. We're
so-
absolutely trying to get rid of the case.
And wasn't the gentleman in Balistrieri trying to do the same thing?
Yes, I think a motion to dismiss, you can argue, is trying to get rid of the case. Yes, but the underlying, in that case, there was no underlying matter that still needed to be resolved. So the idea is, well, you're trying to get them on notice before you spend all this money in litigation through the case, and that could potentially still happen in New York.
Wouldn't that still obtain here, though? To the extent that briefing and the evidentiary hearing and the appeal required the expense of attorney's fees and costs? I mean, isn't that rationale Ballesteri sort of on all fours here?
Yes, but I would challenge it in the sense that if we're going to say that you have to give the opposing party notice in pleading. I mean, what would the word pleading mean if we just extend it to everything?
I understand that, and if we're pre-Ballesteri, you've got a far stronger argument. Nobody's saying you filed a pleading, but Ballesteri didn't require a pleading. Ballesteri addressed a 12B motion, although it was 12B6, whereas yours were 12B2 and 12B5. But, I mean, the same concept, it's sort of, you don't get to wait and see and let everything sort of move through and then see if you want attorney's fees. That's Ballesteri in 15 seconds is kind of that. So help me understand why this case is so much different than Ballesteri, recognizing there's no claim that you filed a pleading, as that term is defined in Rule of Civil Procedure 7.
Well, I'd also say this is our case is a post-judgment filing. It's not a answer to a complaint. So
I get that. It's not a pleading. And it is a post-judgment filing for a case that was pending in New York. And the motion itself cites Rule 12.
yeah, and I can certainly understand how Ballesteri can expand upon what would otherwise be clear to me as pleading defined under Rule 7A as a pleading. But I don't think that makes it expanded to everything that anyone files. Even though in some sense it could potentially end the case. So I don't think if anyone's, I realize the distinction is a slight distinction, but it's an expansion of a rule that kind of missed the point of defining a word in the Arizona rules, and then just ignoring the definition and saying, well, this is close enough.
Wouldn't your argument be better if you hadn't cited Rule 12B?
If we hadn't cited Rule 12B,
Yeah.
and not called it a motion to dismiss, it would be a much stronger argument. It's just, I mean, the ultimate purpose of our motion, though, was to vacate the filing, the domestication.
Was so you needed to go no further in Arizona. Is that fair?
Yes, that's correct.
And- But isn't that rationale exactly the same as Ballesteri? In other words, the theory behind Ballesteri is if the motion itself, seeking relief under 12B, says, oh, by the way, we're also going to seek attorney's fees, that gives the other side an opportunity to think real hard and say, you know what, as opposed to briefing this, and I'm painting a picture that we'll never know existed, but instead of fighting this out now, maybe we should all just go back to New York and save our fees here and see what happens there. I mean, isn't that kind of the rationale when I read Ballesteri, at least?
Yeah, I mean, I think that would be a kind of a far stretch from the
I-
reality of the situation.
I'm not saying that that's the factual pattern here, but that's, as I see it, it is sort of a fundamental fairness under Ballesteri, that you shouldn't have to wait and see whether a party wins to see if then they're also going to seek attorney's fees. Because I'm thinking in this file, if we looked at the Superior Court file real carefully, the first time that fees come up is after the August 28, 2013 minute entry is issued, and then there's a request for attorney's fees. Is that, I mean, if I,
That's correct, yes. The only thing I would note is that, you know, I think any good attorney, when they have any sort of contract dispute against their client, for their client, obviously fees come into consideration as, you know, you could lose fees here, you could win fees here.
Sure.
It could become much bigger than whatever your contract dispute is.
no question, and as I read Ballesteri, though, all it says is, hey, you need to note that up front. Is that fair?
Yeah, that's fair. I just would say that although it's a small distinction, it's that the motion we filed isn't a motion to dismiss under Ballesteri, and it's really a post-judgment motion, and there's also still another motion to dismiss to be filed in New York.
Where I presume Ballesteri wouldn't apply, but I don't know New York law, and okay, all right.
I have the acceptance structure, yes.
Great.
That's all I have.
Thank you, Counsel. Mr. Hammerman.
If I heard counsel correctly, he said this is nothing but a default judgment in New York, and therefore, obviously, the judge in the state of New York is an automaton who sees a default, stamps it, signs it, says it's done. I think that's a great leap. I know that doesn't happen in the state of Arizona. I don't know what happens in the state of New York, but judges and court officers address and analyze and look at the documentation before they sign default judgments. They don't just sign them. So therefore, I think that to just push aside what the New York court did because it was a default judgment has no merit. Judge Thinley, you just mentioned fundamental fairness. And fundamental fairness was not accorded to the appellant in this case. Why was it not? It was because we go through an analysis of whether or not Mr. Kilgore worked for American Lawn Company, American Lawn Partners. There are so many witnesses who could have been brought in about that. Discovery would have had to be conducted. We would have had basically a trial on the merits. And to accept his testimony as being truthful is a real stretch. This is a gentleman who testified at the Superior Court level that there was a conspiracy against him. It was a conspiracy of his co-defendant, Daniel Palatz, her boyfriend, Mr. Johnson, a conspiracy of the person who notarized his signature, and a conspiracy of the process server. So this man had very little credibility, And to go forward and to expect the plaintiff to come in and prove its case in Arizona, that's what is not fair at all. So we talk about fundamental fairness. This is why I have argued repeatedly that the process filed by the court was an improper process. It really did not go to the issue of jurisdiction. I do want to address the issue of attorney's fees. I think the court understands the Ballesteri case very clearly. You have to, when we ask for attorney's fees, it's not on a contingent fee basis. We don't just ask when we win. We have to absorb the risk, because when we ask for them, they might be worded against us as well. And that's what did not take place in this case. I'm in that uncomfortable position of asking the court to reverse the trial court's finding below concerning attacking the validity of the judgment, but to affirm the aspect of the decision concerning attorney's fees.
Thank you.
Thank you.
Counsel, we appreciate your arguments. We appreciate your briefing. We will take this matter under advisement. We'll issue a written ruling in due course. We stand adjourned.